Bismillahirrahmanirrahim. Assalamu alaikum. Today's lecture is on a special request of law students for preparation of law gate and other junior lawyers, and the topic is Qanun Shahadat, law of evidence on fingertips. My name is Sajjad Gopal. I am MBA Finance first position holder from IBA University of Sindh Jamshoro. I am LLB first position holder from Qaid-e-Azam Law College, Nawab Shah, Sindh. I am the first advocate Supreme Court in the history of Nawab Shah Bar Association, and I am the youngest advocate in the history of Supreme Court of Pakistan. I am practicing mainly at Supreme Court Islamabad, having more than 1000 cases pending at Supreme Court and more than 100 cases reported in PLD law books of Pakistan. My three most famous cases are reported in 2019 SCMR, page number 2063. My second case is reported in PLD 2020 Supreme Court 293. And my third and latest case is reported in PLD 2022 Supreme Court, page number 64. Due to busy schedule of cases, I cannot attend calls. Therefore, I always request you to contact me on my WhatsApp number 0333 2682 as soon as I, along with my legal team, will be free from busy schedule. We will coordinate you and guide you in accordance with the law. Please subscribe my YouTube channel, like this video and share in groups. My Facebook page is Sajjad Gopal AC at Facebook, and my page is GSG Law Firm, Nawab Shah, Hyderabad, Karachi and Islamabad, available on Facebook. You can like, follow and subscribe it. Let's start our lecture on different points of Qanun Shahaadat, the law of evidence. I have already delivered more than 10 lectures which are available on my YouTube channel. You can watch those lectures on if you want to understand the articles of Qanun Shahadat in detail. This is an overview that I am going to teach you. Law of evidence has three parts, and those three parts are divided into 13 chapters. The largest and widest chapter is chapter number 3. It starts from article 18 and ends article 69. It has 53 articles. The smallest chapter of law of evidence is chapter 11 and 12. They include only one article. Part number 1 of law of evidence is relevancy of facts. It starts from chapter number 1 to chapter number 6. Part number 2 of law of evidence is on proof. It includes chapter number 7 and 8. Part number 3 is production and effect of evidence. It includes chapter number 9 to chapter number 13, 4 chapters. The most famous articles of law of evidence are I have categorized and simplified them into 8 famous articles. Number 1 is confession, which is described in article 37 to article 43. What is the confession of an accused? Confession of guilt. Then is second is expert opinion. It is described in article 59 to article 65. And on the point of article 38, I have elaborated it in detail in a lecture on my YouTube channel. As I mentioned, that more than 10 lectures are already available on my YouTube channel about law of evidence. Article 38 is very famous, that if any accused has confessed his guilt before police officer in the police custody during investigation or interrogation, it has no value at all. Then is number 3, documentary evidence, which is described in article 72 to 84. Fourth famous article is certified copies of public document. It is described in article 87. Then is number 5, famous article, burden of proof. Burden of proof is defined in article 117 to 129 of the law of evidence. And then 6th is cross-examination. Cross-examination on accused or any witness is described in the law of evidence, Qanun Shahaadat, in article 130 to 161. And 7th is special oath. The special oath is a proceeding, is a very, very famous proceeding in civil cases. One is normal oath, which every witness has to take during the trial of civil or criminal. Other is special oath on Quran Pak. One party has to give offer and the other party, for an instance plaintiff in a civil case, offers the defendant to take special oath on Quran Pak. He will accept the plea on oath, otherwise he will not. And if the defendant refuses it, then the proceeding ends. But if the defendant or other party, if the plaintiff offers, defendant accepts, or defendant offers the offer of special oath and plaintiff accepts, then it is a final agreement in the light of the judgments of Honorable Supreme Court and High Court. Article 163 of Law of Evidence, the Qanun Shahaadat says, and PLD, the famous judgment of Lahore High Court, PLD 2010, Lahore 484 says, once an offer made by one party and other party has accepted it, it becomes a final binding agreement in the court, and no party can go back from that position. It is a final agreement. It is a binding agreement in the court. It is further described in 1981 SCMR, page number 162. And then is Article 146, which is also a very important article you have to remember. When the lawyer is cross-examining, asking questions from your witness, you have the protection in Article 146 that indecent or scandalous questions cannot be asked. Normally, in several trials, when my witnesses were being examined by the other respected advocates, counsels, whenever I felt that my witness is losing his tempo, losing his confidence, and such harsh question is being asked, then I have raised objection, and you must raise this objection, that Honorable Court is empowered under Article 146 of the Law of Evidence, Qanun Shahaadat, to stop a lawyer from asking such questions which are indecent or scandalous. So, Qanun Shahaadat, the Law of Evidence, part number 1 is relevancy of facts, and chapter number 1 is preliminary, chapter number 2 is of witnesses. It starts from section Article 3, who may testify. I have delivered a lecture on this article, who may testify, in detail, available on my YouTube channel. You can watch it. It starts from Article 3 and ends at Article 17. Chapter number 3, relevancy of facts, starts from Article 18 and ends at Article 69. It includes relevancy of facts, admission, statement by person who cannot be called as witness, statement made under special circumstances, how much a statement to be proved. Again, on this point, I have delivered lectures in detail. You can watch those lectures on my YouTube channel. Judgments of courts of justice, one relevant. And then opinion of third person as experts. Opinion of experts. Article 59 is very important. 59 to Article 65, in which expert opinion is admissible and given value, such as ballistic expert or doctor or any other expert. Then is chapter number 4, oral evidence. It has only 2 articles, 70 and 71. And then chapter number 5, documentary evidence. Very important. This documentary evidence is described in Article 72 to Article 101. Documentary evidence, public documents, and presumptions as to documents. And then chapter number 6 starts exclusion of oral by documentary evidence. Article 102 ends at 110. Part number 2 then starts on proof. It starts from chapter number 7, facts which need not to be proved. Means if any party has admitted a fact, it does not require to be proved. Now the burden of proof shifts from you to that witness that party or witness who himself has admitted a point. So, chapter number 7, facts which need not to be proved, Article 111, and then ends at Article 113. And then is chapter number 8, estoppel, having 3 articles. Part number 3 is production and effect of evidence. This is described in Article 117, burden of proof. The burden of proof starts from Article 117 and ends at 129. And then is chapter number 10, the examination of witnesses. It starts from Article 130 and ends at Article 181. Then chapter number 11 starts improper admission and rejection of evidence. It has 1 article, 162. And chapter number 12, decision of the case on the basis of oath, Article 163, that I have defined earlier, that whenever one party has offered and the other party has accepted, then it is a final agreement. It cannot be withdrawn at any stage afterwards. Chapter number 13 is miscellaneous. It starts from Article 164, production of evidence, and it ends at 168, which is repeal. Thank you very much.